Welcome to our behind the scenes look at this interview for the 5 o'clock and our live Facebook conversation with the audience. Joining me today is Todd Foster. Todd is an expert in the kinds of cases that we're going to be talking about. Primarily, we're talking about the Michael Drejka case, the Clearwater shooter case. It's been called the Stand Your Ground case. We're going to talk about that in a minute because it's not a Stand Your Ground case, ironically. It's a self-defense case. Todd's area of expertise comes from several areas. He was an FBI agent.
Yes.
And he is a criminal defense attorney now.
Correct.
You also have another hat that you wore that's really useful for this conversation.
I was a federal prosecutor for 10 years.
So you know exactly the inner workings of this kind of case. So let's talk a little bit about first jury selection, because that's what's going on today in this case, or voir dire as it's called. What do you think is going to be the challenge for both the prosecution and the defense when it comes to seating a jury that's going to be favorable?
Well, the biggest challenge is not to find people that are favorable. The biggest challenge is to find people that are terribly unfavorable. So you want to seek, as a lawyer, whether for the prosecution, for the defense, you want to find the people that absolutely positively are going to be against you, whatever the evidence be. So it's less about finding the ideal juror who's going to go with you than it is about finding that juror who, no matter what, is going to vote against you.
What's going to be hard to eliminate? Because they call that the strike zone, right? That's what lawyers talk about, the people that you want to strike. What's going to be hard in the population in Pinellas County about doing that, about eliminating a juror who could ruin your case?
The most difficult part is that jurors, sometimes they're embarrassed or sometimes they're shy, and they will not share their true feelings. So it's a technique. It's an art that has to be developed by a lawyer, has to develop the skill, the talent, to be able to identify from a juror what he or she is really thinking and to ask questions which give insight into the juror's thoughts. For example, a big issue to me in this case is a juror's view on guns. And there are some people, when they find out that there's a weapon involved, a gun involved, automatically may be predisposed against the person possessing the gun. Mm-hmm. Now, will they admit that? So if you were to ask a juror, Mr. Juror, and the evidence here in the case is going to be that my client had a gun, do you feel because he had a gun, you're likely to rule against him? The person's not going to say yes, right?
So they ask more in-depth questions, I find, when I've watched, and I love watching voir dire. If you've never done it before, it's fascinating. They have questions that they ask these jurors, and they'll say things like, Mr. Foster, have you ever been the victim of a crime?
Right.
They'll start with that. Well, yes, I have. Well, can you tell me a little bit about that? Was there a weapon used in that crime? Did you have a weapon on you at the time? And then all of a sudden, you start to see that person's emotion come out. And that's really what you need to see, because this case, on one side, if you're prosecuting this case, it's about the facts. If you're defending this case, I think it's about emotion.
I don't know about that.
That's my theory.
Well, you may be right, but I think it's about emotion on both sides.
Okay.
I think that there are a lot of people who will be very offended, legitimately, by somebody unarmed being killed by somebody who's armed.
Right.
And I think that there are people on the other side who are going to feel very strongly that I have a right to carry a weapon, and if I have my weapon and if I feel threatened, I should have the right to use it.
Just because you carry a concealed weapon or carry a weapon openly, though, does not give you a license to shoot an unarmed person just because that person ticks you off.
It doesn't give you the right to shoot an unarmed or armed person. The only time that you are justified under Florida law in using deadly force, shooting a weapon, is when you feel you're in imminent danger. That is, if I don't use that weapon right now, that person against whom I'm going to use the weapon is either going to kill me or cause great bodily harm to me. It has to be imminent. You have to feel I have to use this weapon now, not 10 seconds from now, but right now. If I don't use it right now, I'm going to die.
So let's take a look at the video, and we're going to talk a little bit about that issue, because I think when the viewers look at this video, and Chris is our person back in the control room, and he's going to be playing this back for us and stopping it. Feel free to start asking your questions here. I'm going to read them so that Todd can answer your questions about this case here on Facebook Live in real time. And then, of course, a lot of this will be in our 5 o'clock newscast. We hope you'll tune in for that as well. But if we could go ahead and just start the video, because this is going to be what the jury is going to look at. And they're going to see this in slow motion. So there you see Marquise McLaughlin. He comes out of the convenience store. shoves Michael Drejka to the ground. There he is. And look how quickly he pulls that weapon. It's 1001, 1002, 1003. It's a very quick reaction. What do you think the role of the speed of that reaction is going to be during this trial?
Well, I think playing this tape in slow motion is a victory for the state and a big defeat for the defense, because Drejka's reaction wasn't in slow motion. Drejka's reaction is based on real time. And it's real time, there's adrenaline, there's circumstances, he's trying to take in everything, so he's making a decision like right now. By breaking this down and slowing it down frame by frame, that I think is a real advantage for the state, because the state can say, look at that, and look at that frame, and look at that frame, and look at that frame. Meanwhile, the person on the ground, Drejka, is not processing frame by frame. He's processing as he's seeing it.
It was a quick decision. There's no question.
It was a quick decision, and you know, people who have never been in that situation, you know, it's a big decision, you know, and it's not
There
easy.
it is.
So we take a look at that. So the fact that he draws his weapon and points the weapon at the individual, that is not what this trial is about. So that would be a different story. That's not use of deadly force. Pointing a weapon is not the use of deadly force. Pointing a weapon is...
Shooting somebody in close proximity is deadly force, though, and they
shooting
were
the
in
person,
close proximity.
Shooting the person. So the question becomes, so he draws his weapon. So the issue in the trial isn't whether or not he was justified in drawing his weapon. The issue in the trial is whether he was justified in drawing his weapon, holding the person at bay for tick, tick, and then pow, firing. So the issue in the case is the discharge of the firearm, not the unholstering and pointing of the firearm.
So let's talk about self-defense in Florida and what's required if you're making a self-defense case, which, by the way, this is a self-defense case. The headlines that you see in the news frequently are stand your ground case. This was not a stand your ground case. Initially, as you may remember, Michael Drejka had said he was going to assert that he was not guilty, that he was immune from prosecution under our stand your ground laws. And Florida has a very generous stand your ground law, a very broad one. You do not even have a duty to retreat, and the burden is on the prosecution to prove that you did something wrong. So the nuances of that law have changed very, very recently. And in this case, his attorneys, once he was charged, they did not opt to have a pretrial motion to ask a judge, which it would have been just a judge making this decision, to grant him immunity under stand your ground. They decided to go ahead and they're going to go to trial, which is beginning now, and they're going to put on a self-defense case. Why do we still hear people talk about stand your ground, though? What does that have to do with this case?
Well, stand your ground has to do generally with something known as the duty to retreat. So typically under the law for hundreds of years, a person had a duty to retreat, that is to withdraw. So if you're in a deadly situation, your obligation is to remove yourself from the deadly situation if you can do so safely. And one of the early exceptions to that is what's known as the castle doctrine. So in my own home.
Home's your castle.
My home's my castle. So if someone were to break into my home, I don't have to run out the back door. I can stay in my home and protect myself and use deadly force if necessary. Florida has essentially taken the castle doctrine and applied it to the street. So you have the right to stand your ground, not retreat, so long as you, the potential shooter, are not committing a crime yourself, and you're in a place you have the right to be. That is, you're not trespassing or committing a crime.
Which this would qualify.
Which this would qualify.
Why did his defense attorneys, in your opinion, in your expert opinion, why did they look at this and decide there is not a snowball's chance in Hades that we're going to go in front of a judge in Florida who's going to say, this is immunity, understand your ground? Why do you think they made that decision not to go for that?
Because the judge would still have to find that the person was reasonably in imminent fear or felt reasonably in imminent fear of death or great bodily harm.
And why is that problematic because of this evidence? What do we see on here that works against him?
I think what we see in here which works against him is that the gentleman who was shot at one point, I think, takes a step or two back. We could play that maybe and see that.
Yeah, Chris can play that for us.
Yes,
We
Chris,
can look at that.
if you would.
So here we go. We're resetting the clock here.
Okay.
And we know that there was a conversation that took place, by the way, before this. We don't have audio, so the jury will not have the benefit of hearing the conversation or argument that ensued that led to this interaction.
But the jury will hear from the witness, from the young lady who was there, so they'll get some evidence of that.
So here we go. So this is all over this parking space. Here he comes out.
Here's the push.
And you see the push.
Okay.
1, 2, 3. There it is.
Right. So, and
And he pulled the trigger.
well.
We don't show
so-
that part, by the
But
way.
is that the end of the tape?
That is the end. We have to show it. We have to stop it right there because right after this, the bullet leaves the chamber and you see the actual
Okay. So
death.
the quality of what we're seeing here is a function of the instrument that recorded, the camera that recorded
We also
it.
have it blown up.
But you know,
big time.
I'm not really sure where the arms are. So the arms,
He's like this.
no, this gentleman
Oh,
here,
Marquise, yeah.
Marquise, his arms appear to be down. He doesn't appear to be reaching for anything.
He goes like this after that, though,
Okay, well that's even worse for
Yeah.
the defense. So that's a submissive
and then he
type
turns.
gesture and turning the body. So those are issues that the defense will have to contend with and would have had to contend with those were this to be heard by the judge alone. So the
So
defense
that's why they went with self-defense.
could be. They may also have a theory.
By the way, make sure that they can see this. 'cause
Sorry.
Yeah.
They may also, the defense may also have a theory which they did not want to publish or reveal pre-trial. And you know, lastly,
You have to show your hand.
you have to show your
that.
hand, and sometimes or frequently in these cases, the accused will take the witness stand and testify. And if the accused takes the witness stand and testifies, then he gets cross-examined by the state. And that's a method by which additional information is obtained and, you know, could be used against him.
They don't want him testifying, his attorneys, right?
Well, I don't know if they do or not, you know.
I mean, would you guess that they would?
My guess is that they may think that there's enough on this video that they don't need him to testify. What more could he say?
Yeah.
You know, but depending, like if an independent witness has something to say that he or she heard or saw,
Right.
you know, and also another factor in this case is the judge has ruled that an independent event is admissible. So another incident where allegedly he confronted someone who was
We can't
parked.
see him.
Yep.
Just to make sure. Yeah.
All right.
There you go.
So
you're-
allegedly another incident where he. in
Oh, his
similar
prior bad
circum-
acts.
The prior bad act.
Yeah.
Although that didn't
Mr.
result.
Drejka has done this before in some form or fashion. The people who were in the car are the ones that I believe are going to be admissible. There were certain circumstances that could be and could not be admitted. That was one of the pretrial hearings that you and I actually talked about on Facebook Live. So we had some incidents where he did something that was similar enough,
Right.
and you talked about the legal standard for that. So the jury will be able to hear some of those stories.
The judge ruled that the jury can hear about one such prior incident.
And these were two people who were in a car, I believe, that he threatened.
Yeah, I'm not sure, but what that was, but the distinguishing factor there, of course, is that there's no shooting and use of deadly force.
Yeah, he didn't kill him. He said some things to him that would have implied that he was going to. So it was a threat.
There's a threat, but
Yeah.
we don't know if he was armed at that time. I don't recall whether he drew a weapon at that time. But
He displayed a weapon.
he displayed a weapon, but he didn't employ it. So,
Right.
So here he plainly did, and there's no question about that.
So let's look at this video again since we have it here and since we have Chris to play it over again from the top. And we were talking about stand your ground versus self-defense. Why do we keep hearing people bring up stand your ground? Will stand your ground have anything to do with this trial because it's a self-defense case and not a stand your ground case?
Well, the stand your ground deals with the duty to retreat.
Right, but does it play a role in this trial?
It will play a role in this trial, so the prosecution cannot argue, in my view, he should have got up and ran away.
So that is still part of this.
That's still part
That
of it. It's
part
part
of
of
the
the
law.
jury instruction. And at the conclusion of the case, when it goes to the jury,
Even if it's self-defense.
even if it's self-defense, the judge will say that the defendant had no obligation to retreat if he was in a place he had the right to be and he was not engaged in the commission of a crime.
You and I also talked about, and we can start this over again, the proximity of the two of them. The other thing that we talked about, Todd, and you've looked at this in other cases too, is when the homicide detectives did the crime scene analysis, they found that Marquise McLaughlin was actually in a state of retreat and that he was turning away from the defendant. And you can kind of see that. You see his body sort of turn right there, right at that moment. So he was hit. The trajectory of the bullet was such that he was hit while turning his body. How damning is that? How bad is that?
Well, you can look at that two ways. You know, turning the body can be evidence of some retreat, but turning the body is also some evidence of employing a combat stance.
Okay.
Well, you just think about when you see boxers, you know, they blade or put their bodies because you're narrowing your exposure. Even things like yoga, the warrior stance is a bladed stance.
That's true.
And as law enforcement officers, you're always taught to shoot from a bladed, so when they have less of a target of you. So the bladed stance, I assume, will be argued to be like a fighter stance or an aggressive stance.
If you were arguing this case and telling a jury about this video as a prosecutor and as a defense attorney, walk us through what you would want them to see.
Well, I think what the prosecutor will argue is that this gentleman was unarmed, no reasonable expectation that he's armed, his hands are down, he's retreating, and he poses no imminent threat. That there's no threat, that the shooting is out of anger and is unjustifiable and it's homicide. And he had time to reflect. That's another thing when you talk about homicides, you talk about intent. Did the person have time to, should I do it or not do it? So in that tick, 1 or 2 seconds, he's thinking, deliberating, right? Deliberation, intent, that he had time to think about it and said, okay, bam.
Is that what when they say mens rea, is that what they're talking about?
Mens rea means criminal intent. So there's two things. Mens rea means criminal intent, and actus rea means a criminal act. So you can do an act, so a shooting can be an act, but unless you're doing it with a criminal purpose, it's not a crime, like self-defense or people at war. You know, we train our soldiers to go to war and to shoot the enemy. Mm-hmm. So, but that's not a crime because the soldier doesn't have criminal intent. He's under a soldier's oath to protect the country.
So if you're arguing for the other side, tell us what you would want
the
the jury.
defense?
You're talking to the jury and you're instructing them and you're trying to tell them what they should be seeing here. What do you want them to see out of this?
From the defense standpoint?
Yeah.
I think what the defense will say is that this was an angry, larger, motivated person who's already been violent to Drejka. He shoved him and knocked him down. Mm-hmm. And that Drejka perceived the guy as being prepared to once again advance on him, and that Drejka probably thought that given the circumstances that this guy was going to really cause him grievous bodily injury.
Just want to make sure we have a couple comments on here. One of them is they just want to make sure that they can see what you're talking about because they're listening to what you're saying, but they want to make sure that they can see this is Marquise McLaughlin, and then you have the defendant, Michael Drejka, who's on the ground. So the fact that the victim, even though unarmed, was a larger person could work against the victim.
Well, it's a circumstance, and what the judge tells the jury is that you should consider all of the facts and circumstances that a reasonable person would have considered under those same circumstances. Mm-hmm. And the relative size of people, somebody who's bigger and stronger is more of a threat to someone than someone who's smaller and weaker. And that's a factor. So if Drejka thinks, well, this guy's bigger and stronger than me, if he gets a hold of me, he's likely to, crack my head. That's a legitimate fact.
Can you think all of those things in 3 seconds, though? Because that's a tough argument to make.
Of course you can.
So it's hard to argue that you were analyzing this guy doing all these future things to you when you pulled out your gun and fired it that quickly.
These are instinctive thoughts.
Yeah.
These are instinctive thoughts. As human beings, we get into a fight or flight. You've heard of that fight or flight situation. Mm-hmm. And the first instinct, of course, is to protect ourselves, to protect people around us who we love. So, for example, I suspect that like McLaughlin, he viewed his girlfriend, his wife, in trouble, and that's why he acted as he did. He doesn't know this guy from anybody.
Does
He's
it
there to
matter,
protect the woman.
though? That's another question that a lot of people are asking. Does it matter that he started it? People say, does it matter that it appears? Now, we don't know what preceded this, right? We don't know the language. We're going to hear from one witness. We know that witnesses can be reliable. Sometimes they can be really unreliable. So her memory of what was said will be told to the jury. But we don't have audio on the previous argument. But visually, you see Marquise McLaughlin, and we can re-rack that if we can. Chris can replay this for us. You see Marquise McLaughlin shove him. And you see that very clearly on the video. There he is walking out of the convenience store. He sees Michael Drejka arguing with his girlfriend and then shoves him. So a lot of people have asked, well, does it matter that the victim in this case, even though unarmed, started the physical fight here?
Well, I think it does.
Is that a factor?
I think it is. Because if you're defending Mr. Drejka, then Drejka knows that this person has already attacked him and attacked him, well, violently. He shoved him to the ground. Mm-hmm. So that's part of his cue of what's going on in his mind.
Legally speaking, does it matter in terms of the law, or are you saying in terms of just the emotion of a juror?
Both,
Okay.
because when he's trying to determine whether or not he's an imminent physical threat of physical imminent death or injury,
Yeah.
he's already thinking this person has already attacked me. And he's standing over me. I don't know exactly what this distance is. I saw where there's some discussion about expert witnesses. I'm going to talk about the zone of danger, the
Yes.
length of space as to that.
The close proximity, what does that have to do with anything?
The close proximity talks about how vulnerable you at what distance. So me from you now maybe 6 feet away. Mm-hmm. So could I attack you within 6 feet? Probably, but would you have time to react? Maybe, probably, but if I'm 10 feet away, I'm less of a threat. If I'm 5 feet away, I'm more of a threat.
And that's what the homicide detectives ultimately concluded, and you and I talked about this evidence, that they made the conclusion, and correct me if I'm misremembering this, that he was too far away to qualify for imminent threat, and that's why they went with the first-degree manslaughter charge in this case. Is that right?
That's part of it, but there's no law that says 5 feet is close enough and 6 feet isn't close enough.
It's interpreted.
It's interpreted, it's a jury question. So was it reasonable? Was it reasonable? And here's the question for the jury from the defense. Was it reasonable in the circumstances of this person in real time, with everything that happened, was it reasonable for him to believe that Mr. McLaughlin was about to, that is imminent,
that Marquise McLaughlin was going to harm him?
Seriously harm him. And shoving somebody down to the ground isn't serious bodily harm.
Nope.
Seriously bodily harm is like
I'm coming at you with a chainsaw.
breaking your arm or cracking your head or something like that.
Yeah.
So if he had like a big stick, or if he had a pipe or something like that.
The role of the word reasonable always is fascinating to me in a court of law. And so for the sake of our conversation, it would be interesting to hear you say what that means, because it's what a reasonable person would do in this situation.
Right.
What does that mean, and why are jurors told that?
So a reasonable person standard is also known as like an objective standard. So the question isn't what would I do in that circumstance, although all of our thought processes devolve to that anyway. What would I do? But the question is, what would the average person do? What would an objective person, someone who's not at this extreme that I would shoot anybody who came near me, or this extreme, I wouldn't shoot anybody that came near me.
Something
what would
in the
the
middle.
average, something in the middle, the average objective person, a common denominator person.
But people, we know this, people aren't like that. I mean, people really aren't reasonable. We are not rational beings in our entirety. And especially when you bring in the gun issue. You started with this, and I think that's a good place to come back to. We aren't reasonable, rational people when we're confronted in a situation like this and we're carrying a weapon. Mm-hmm. And so is that going to sway a jury that is potentially concerned about other gun issues?
Yeah,
emotional?
That's, to me, that's the overriding issue in the case, is how people feel about guns, how people feel about self-defense, use of deadly force.
So if I find this guy guilty, this could threaten my Second Amendment right to defend myself, to carry a weapon, that they think that there's some kind of slippery slope.
Right.
I hear that term a lot.
This could change the law. I like to carry a weapon. I like having my gun in my house. And I don't want to see the law changed to prevent me. And that
Could it change the law, though? Is that naive to think that? Or is
Well,
it?
I think with everything that's going on in the country, this could be another straw into the basket on the camel's back. So,
Okay.
I don't think this is front and center or first and foremost, but this whole issue, this horrible issue we're experiencing in the country with gun violence, is going to lead to some changes.
Anna's reaction, and we can play this again, Anna's reaction is Drejka was pushed down hard.
Yes.
So from her vantage point, watching this from home, she sees that interaction as a very violent act. Is that something that you think is going to come across to a jury in the same manner? Or can two jurors look at that same video and have a different interpretation?
Well, I think objectively, when we look at the screen, he pushes him with sufficient force to knock him to the ground.
True.
And he pushes him from the side, and I don't think that Drejka necessarily saw him coming. So
Caught him off guard.
Caught him off guard. So when Drejka's on the ground, there's some element of confusion going on too. He's trying to orientate himself as to what's going on. He's having this conversation.
What
with
just
this
happened
woman.
to me?
What just happened? Oh my gosh, here's this guy. Oh my gosh, he's bigger and he's angry and he's stronger. What am I going to do? What am I going to do? So that's the defense.
But when you get that license, and anybody who's a concealed holder or concealed carrier is going to know this, who's on the jury, you're told not to pull that thing unless you are going to use it against an attacker. You're not told just to pull it out anytime you get knocked over or surprised. So that could backfire.
Or support him because yeah, but his training, I don't know what type of training he has, but if his training is that you don't pull your weapon unless you're in imminent fear, right? Then his default, his reflective conduct is that I am in imminent fear and here comes the weapon. So if he's abiding by his training, that you should only pull your weapon, draw your weapon when you're in imminent fear of great bodily harm, the fact that he pulls the weapon is in some ways corroborative.
So it's better.
It could be better, depending on how it shakes out, depending on how it's argued.
If you had to argue this case, would you rather be on the prosecution or the defense? Well, from a lawyer's standpoint, what would be easier?
No, I'm not going to answer that.
Who has the bigger challenge, do you think, in the case?
I think the defense always has the bigger challenge
always.
In a case like this.
Well,
you have a victim, you have a dead person, and I think self-defense is not an easy defense.
Connie's got a comment. She says he didn't have a problem confronting a woman. Why not a man? Meaning Michael Drejka had confronted this man's girlfriend, the mother of his child,
yes,
in front of the child. So that's kind of an interesting argument in favor of the prosecution, because you have a sympathetic victim to some degree who's defending a guy who's picking on his girlfriend.
Yes, and to pick up on that, you have a hostile individual. You have a person who has already demonstrated hostility towards a loved one of Mr. McLaughlin.
Mm-hmm. Yeah. Shauna says the store owner has advised him to stay away from customers. Going back to that history, how damaging is that going to be? Because they are going to hear from those people that this guy was a regular. It's not like this guy showed up one day and this happened. This is a guy who picked fights with people. And that's an observation of fact when you get it from witness after witness, that this guy was a habitual arguer, if nothing else.
So if he's an habitual, see again, and this is something that has to be parsed by the defense, and the state will deal with it in their own ways. But being an arguer, or I don't know what it's about handicap spaces,
right?
Where he's
people get mad about that.
Well, he's personally offended by it, and there must be something in his background which triggers that.
Mm-hmm.
But the fact that he argues with people is one thing. The fact that he resorts to gun violence against someone is another story.
If you had to say one thing, one bottom line thing that you would want our viewers at home to see when they look at this, in terms of just having the right information about this trial, what would it be?
What it would be is, did Drejka act in order to prevent himself from being killed or seriously injured at that moment? That's the question. That's what it boils down to. Everything else is just insight into that question. But the question comes down to this frame, which you have up there. Mm-hmm. Is he an imminent threat of death or serious bodily injury at this point in time? If he's not, then he's guilty. I'm
going to take one more question. It's really a comment, and I think this is good to address. I'm going to read it exactly as is, because I get a lot of these comments too, and I have to kind of break them down and explain some of these things that are not exactly as they might seem. So Danny has the impression that the sheriff determined that this was a stand your ground case. That's not what happened. He decided to take himself out of the picture and to allow the process by the people who are supposed to do that kind of thing to continue. He wanted prosecutors to look at the case, investigate, and decide whether charges should be filed. So that was not, the sheriff didn't come out and say this is clearly a case of stand your ground, which many people have the perception in their memory that that's what took place.
Well, what the sheriff did is the sheriff said, I am not going to arrest him.
Right.
Because it's not clear to me that it's not stand your ground. You know, people get
Double
arrested.
negative. It's not clear that it's not.
People get arrested in this county and other places all the time for shooting other people. But in this particular case, he did not authorize the arrest because there was some question in his mind as to whether or not this was justifiable use of deadly force.
And I think that was probably smart of him to stay out of it and to allow prosecutors to look at the facts and bring charges and then make an arrest.
Well, our sheriff is a very bright guy, and
he's not a dumb guy.
He's not dumb by any stretch, and he understands the law and he understands circumstances, and I think he made a call there which he thought was correct.
Yeah, the perception though to people like Danny, let me read this comment. I get comments like this a lot. Danny says, even the sheriff called this a justified shooting the day this happened. I've listened to everything that sheriff said. I never heard him say this was a justified shooting.
Yeah, I don't think that's the phrase he used. It may be interpreted as that, but again, he said, I am not convinced that we have enough to arrest him at this point.
Yeah.
But then
that's different from saying this guy was justified.
It's different than
big
saying
difference.
That, but it's also different from saying there's no way, there's no possible way it's justified, therefore let's go take him to jail.
So that is a significant thing in this case.
It is a significant thing.
And he is a witness.
He saw gray. Well, I'm not sure they're going to let him testify, but
why not?
I think the judges indicated that the sheriff's opinion is not relevant to the jury.
Interesting, because he was on the witness list originally, right?
Yes.
Okay, I'm not misremembering. Okay, so let me read on. Danny says, even said surveillance video, in his opinion, shows he was shoved in a hard manner.
Yes.
And therefore, that was the threat, and he considered it qualified for the stand your ground law. People keep coming back to that over and over again because I think it's an interesting thing. But as you've explained, stand your ground is an immunity, and self-defense is a defense. This is a self-defense case, but stand your ground is still relevant?
Stand your ground.
How would you say that?
Stand your ground is still relevant because he had the right to stand his ground, that is, not retreat, not run away, but only if he reasonably felt himself to be in imminent danger of death or great bodily injury.
So even though they didn't make a motion for immunity, stand your ground still applies to self-defense? Is that a right way to say that?
The stand your ground means you don't have a duty to retreat.
Right.
So he has no duty to retreat. The stand your ground law says that you could get a determination from a judge without going to a jury, sort of like a summary judgment in a civil case. Judge, we win. We shouldn't have to go to a jury because the light was red and everybody agrees.
The judge says you're immune or you're not immune.
The judge says we're done.
Go on your way. If the judge says you're immune, you don't go to trial.
That's right.
But now we're in a trial. It's a self-defense case.
Right.
So I think what I'm trying to clarify for people, because I think it is very confusing, is what role stand your ground plays since this was not a stand your ground immunity case. Now that we're in a self-defense case, how is that law brought in?
The law is brought in because the determination of whether or not this was a justifiable shooting will now be made by the jury and not by the judge. Mm-hmm. But the phrase stand your ground means that I can stand my ground and not have a duty to retreat, but so long as I reasonably fear an imminent danger of threat.
But that's self-defense now, right?
That's self-defense. But the stand your ground, you stand your ground doesn't apply. You don't even get to stand your ground unless there's imminent threat of death or bodily harm.
Okay.
So what we're seeing here differently is that the judge isn't going to decide whether or not the case should be going forward or not. The jury is.
Well, the case did go forward because they didn't have that motion.
Right.
So he did get charged, and this is now a defense case, and this is a first-degree manslaughter case. I guess I'm wondering if they didn't seek that immunity, how that law comes in. Because
well, that part of the law doesn't. That part of the law, so there are different parts to the law.
That's the question.
The one part of the law says that if you go to the judge and the judge agrees with you, the case is over. Mm-hmm. So they haven't employed that part of the law. They're going to prove self-defense, and they're going to say that he was in reasonable threat of harm or death, and he did not have a duty to back off. So stand your ground is the opposite of not standing your ground,
Right.
which would be to retreat or run away. So 10 years ago, the argument would have been, well, he should have ran around the car.
So you don't have to seek that kind of immunity in order to use stand your ground
Correct.
in a defense?
Right.
Okay.
So stand your ground means different things to different people.
Yes, that's what I'm getting at.
The stand your ground law is essentially boils down to that a person can stand their ground and not retreat.
Sure.
And if they feel that they're being threatened, they have the right to stand there and defend themselves.
And the distinction between stand your ground and self-defense is what?
Stand your ground just deals with duty to retreat. So you could retreat and somebody can come chasing you, and then you still have to defend yourself with deadly force. But stand your ground just applies to being able to stay in the position you are, and if the threat comes, you can defend yourself.
Okay. Anything else I didn't ask you before we wrap this up? Have we covered everything?
I think we talked about the slow motion. I think we talked about the weapons angle.
The video playing again right here.
And I think we've covered
There he
pretty
goes.
much all of it.
Yeah. Well, it's going to be an interesting case. Todd Foster, thank you so much for being here. Thank you for your questions. I'll continue to look at them and answer them, and I'll get the expert opinion on that before I give you a response and an answer. But I appreciate those of you who are part of this conversation, and we'll see you tonight at 5 o'clock. Thanks.